Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Don't face that court alone. Let the Wise Man team get you back on the road. Does your license need saving? Do the wise thing. Call the Wise Man team at Wise Man Lawyers.
Alright, today I was at Cleveland Magistrates Court. Client was charged with low-range drink driving, reading a .072. He hadn't lost his licence in the last 5 years. He was the holder of an open Queensland licence, so as a starting point he was technically eligible to apply for a DUI drink driving work licence, but given he was a valuable and valued member of his organisation, he wasn't going to lose his job over this, and it would have been incorrect and wrong to sign an affidavit saying that he would lose his job. One of the prerequisites to get or to be eligible to apply for a DUI drink driving work licence is that you need an affidavit, if you're not self-employed, from your employer saying that you will lose your job or at least your income if you lose your licence. And as I said, that wasn't the case today. So my job was one of getting the disqualification down as low as possible, as opposed to applying for a DUI drink driving work licence. But more importantly, for my client, given the industry he works in, he was concerned about the recording of a conviction. This isn't a criminal matter, it's a traffic matter, but that said, recorded traffic convictions can cause difficulties in certain areas of life. I'm not going to go into details about what he does or why he particularly needed it, other than to say that he's in a role that, a civilian role, but a civilian role that comes with it certain Defence Force security classifications, and those classifications or clearances are granted, and certain hurdles need to be gotten over to be granted such access, but it's an ongoing renewal process. So a recorded conviction today, even though it's not a criminal matter and is only a traffic matter, may have caused him difficulties in the future in maintaining those defence security clearances. So probably more importantly than the licence was the recording of a conviction. But that said, I was here to try and achieve both. Prior to today, I got my client to complete, we give clients a few options with regard to reformatory courses. This particular client chose to do 2 of them, which was good and noble of him. So basically, every possible reformatory course that he could have done in this state, he did. We got him to get some character references based on a template we provide all our clients, which guides the referees through, who they need to be addressed to, the points that need to be covered. There's no point just having a "to whom it may concern, he's a great bloke" reference when you go to court, because the magistrate doesn't know that the person writing it knows it's being used for court. And if the reference, just speaks about the guy in general, how does the magistrate even know that they know of the charge? But in any event, that's why we give templates to our clients to guide the referees. With regard to the recording of the conviction, I drafted pretty detailed written submissions prior to today of various cases supporting my argument that in this instance there shouldn't be a recorded conviction. Magistrates don't give out the non-recording of traffic convictions freely, given that for most persons there's little to no impact. But under certain circumstances it is appropriate for me to push for it, particularly if there's some kind of defence-related employment. As I said, I drafted those submissions, forwarded everything document-wise to the court and the prosecutions prior to today. Met my client at court this morning. We grabbed a conference room, ran through my submissions, the procedure, what he could expect me to say, the magistrate, the prosecutor, etc. There was quite a bit of resistance from the prosecutor on the recording of conviction. Most of the time they take a position that it is of little impact and therefore it should be recorded all the time, and to a certain extent they're correct. I mean, if you just go to court and say I don't want to record a conviction because I just don't want one, well, you're not going to get anywhere. And even when clients or potential clients ring me up saying I want no conviction recorded, my response is why? And I need more than just because. I need to have something of substance that I can put to the magistrate. I mean, case law will only get me so far if you've got no plausible reason for requiring no conviction recorded other than just simply wanting it. But in any event, ran through everything. As I said, went in. There was resistance from the prosecutor, but I was ultimately able to overcome it with my written submissions that I'd earlier prepared and my verbal submissions. So I was able to persuade the magistrate not to record a conviction. And with regard to disqualification, as I said, worst case is 9 months, mandatory minimum is 1 month. I was also successful in persuading the magistrate to give the mandatory minimum 1 month disqualification. So no conviction recorded, 1 month disqualification, modest fine. Client's obviously relieved, very happy. I'm Andrew Wiseman at Cleveland Magistrates Court. Thanks for watching. Hi, I'm Andrew Wiseman from Wiseman Lawyers, Queensland's only truly dedicated drug, alcohol and traffic offence law firm. If you face loss of licence, loss of vehicle imprisonment or anything in between at any court in Queensland, we can and will help you today. This is our specialty. This is all we do. Give us a call, 1300 947 352. I look forward to helping you resolve your issue today.
Don't face that court alone. Let the wise man team get you back on the road. Does your license need saving?